Very good evening to all of you. Pleasure in inviting all of you to this week's online lecture uh, in the Know Your IP series. And we have with us an eminent professor of international law and also international business law, air and space law, Professor Dr. V. Balakista Reddy, sir, currently the Registrar of the prestigious NALSAR University of Law, Hyderabad. And Sir has a very impressive biodata. I think most of you relating to the discipline of law know about the space and air law and also the aviation law. And Sir has to his credit any number of, in fact, seminars, conferences, not only as a participant or as a resource person, but also as an organizer. I have been living, testimony to his achievements as to what he has done to the NALSAR University, the Nobel Prize winning International Institute of Law, then conducting number of programs at the international level and bringing so many projects, and the list goes on and on. His, in fact, achievements are an open book for everyone to see. And Sir is going to speak on the field of World Trade Organization, having delivered any number of lectures, not only on TRIPS, but also, issues like the GATS and many.
Again, thank you for your nice introduction. Good evening, friends. Of course, part of Know Your IP, and today I'm going to speak pre and intellectual property protection, pre and post TRIPS agreement. So what I'm going to look next, maybe 1 hour or so. So I'll begin with what is IPR. You all know that, but just for sake of our understanding, I'm going to touch a minute about knowing, IPR, definition of IP. Then I'm going to talk about more into IP regulations before TRIPS, because I'm going to talk pre and post TRIPS agreement. So I'll also touch upon what kind of IP regulation, IP regime used to be there in the pre-TRIPS agreement. When I'm going to talk about pre-TRIPS agreement, I'm going to touch the Paris and Bonn conventions. You all know, friends, the intellectual property protection started way back in 13th, 14th centuries onwards. It's not that we are talking about the IP in part of the WTO or TRIPS. It was there for almost last 7, 8 centuries. But how this IP evolution happened, I'm going to touch very briefly, but I'll more concentrate on the IP in the GATT and TRIPS part of that. Though General Agreement on Tariffs and Trade GATT, there were certain articles which mentioned talking about the intellectual property, but very few articles. I'm going to talk about that. But more focus will be on that, how IP protection is different from earlier regimes to the present regime. When I say present regime, is it a TRIPS regime or WTO TRIPS regime? So when I'm going to talk about the WTO TRIPS regime, one has to know that, the GATT, under GATT, though IP was very, minimal focus was there, because the reason is that WIPO was there. There were around 20 important international treaties which used to regulate IP. That's why TRIPS, the GATT agreement was not given adequate focus on the intellectual property, but there are certain issues which were mentioned in the GATT agreement. But more particularly, why shift has to be changed from GATT to, or why GATT has neglected, and how the intellectual property regime took over by the WTO. Before talk about WTO, in part of the GATT, we have 8 rounds of negotiation. Prior to Uruguay round, there were 7 rounds of negotiations, but I will focus more on the Uruguay round, 8th round, which actually led the creation of TRIPS agreement and intellectual property. I'm going to touch that. And then what is the outcome of Uruguay round, how Uruguay round touched the intellectual property, and then finally the TRIPS agreement. If you look at the whole gamut of TRIPS agreement, today, though, friends, there are 23 important international treaties which regulate different facets of intellectual property rights. But I am calling TRIPS agreement is the agreement when it comes to the intellectual property protection. I'm using the word the, you can understand what kind of importance this particular agreement has. So I am briefly analyzing these, TRIPS agreement, mainly TRIPS consisting of 73 articles, 7 parts, and everything is there. So I will focus one or two important articles, and finally I'll end with my discussion how India enforcement of TRIPS agreement in Indian context. So our domestic enforcement of TRIPS agreement in Indian context. That is the scheme I'm going to look for next 40-45 minutes. Okay, but I said, what is IP? You all know that IPR, I stands for intelligence, P stands for protection, R stands for rights. Something coming from human mind, it becomes your property. Once you say that it is your property, you have to, your rights, you have to protect that property. So that is simple understanding. My understanding of intellectual property is something created by human mind has become property. That property has to protect it. This is a whole gamut or exercise of intellectual property rights. But for our best known or one of the very wide definition given by the WIPO, Article 2, Clause 8 of the WIPO Treaty 1967, which said IPRs including rights relating to literary, artistic, scientific works, performance of performing arts, phonograms and broadcasts, inventions of all fields of human endeavor, scientific discoveries, industrial designs, trademarks, service marks, then protection against unfair competition. All these things defined, very comprehensive definition given by the WIPO Treaty 1967. That is the understanding of or defining of TRIPS agreement. But one thing, I said my talk pre and post TRIPS agreement. When I say pre-TRIPS agreement, what kind of intellectual property regime was there? How it used to be protected. So the point I am putting here is that yes, from 14th to 19th century, if you look at these 4-5 centuries actually, what kind of IP evolution happened. Of course, whether it's a patents or copyrights, if you look at patents were granted, initial stage of development of intellectual property was bilateral and national level. Okay, so if you look at the protection of foreigners introduced useful arts way back in 1331, and you all know that first patent was granted way back in 1421, Italian state of Florence, and industrial revolutions, first, second, third, all these have influenced a lot intellectual property rights, more particularly that side, patent. And the same thing with, copyrights. If you look at invention of printing, press by Gutenberg, and then, early copyright protection came, protection of publishers rather than the authors, and publishers got protection from the respective kings, sovereigns, from the privileges, territorial privilege, these kind of things were there. And of course, many countries, if you look at way back in 18th century, they have their own IP regime. For example, in England, in 1710, it enacted Copyright Act. We know US 1719, France 1791, 93, all. So what I'm trying to put here in summing up is the IP regime initial stage, 400 to 500 years of history. If you look at IP, whether it's a patents or copyrights, initially it was developed by a nationalist perspective rather than the international perspectives. So countries, again, to protect copyright patents, they enacted their own domestic legislations. But question comes, then these domestic legislations could not protect effectively, or could not give an adequate protection to copyrights. Then the need arose to have international IP regime. So friends, we all know that IP has a cross-border in nature. If you write a book, if you have something, it's not going to confine only to your border. So if once cross-border things happen, then these existing legislations have a problem with the extraterritorial or application of those laws. So that created a problem. Then way back in early 18th, 19th century, if you look at the international community, thought that we should create intellectual property regime part of international things. So that was the idea. And then of course the important international treaties. If I have to talk about pre-TRIPS agreement, I have to mention two important areas. One I call it the Paris and Berne regimes. You all know that Paris Convention 1883 is the first convention which talked about the patents. So that is so I call it is the Paris regime and Berne regime. When I say Paris regime, what do you mean by Paris regime? Paris regime consisting of the Paris Convention for protection of intellectual industrial property way back 1883, and other conventions and treaties relating to patents, industrial design, trademarks. This is the whole, around again 14, 15 important legislations, important treaties we have today dealing with the Paris regime. So summing up, this Paris regime deals with three important aspects: patent, trademarks, designs. That is the Paris regime. Then second important area again is copyrights, or what we call Berne regime. Berne regime deals with the copyrights, and of course today we have a new word we used, part of the TRIPS agreement is the related rights. Okay, so Berne regime deals with the Berne Convention, or Berne regime consisting of Berne Convention 1886 for protection of literary and artistic works, and other conventions on copyrights and neighboring rights. So that is the Berne, again 7 to 8 important international treaties which regulate these copyrights and related rights. That's why I said whole around 20 important international treaties which are part of the international IP regime before the TRIPS agreement. So that's one aspect. Then not only the Paris Berne, but earlier GATT, I mentioned in my introductory part, GATT and IPR, if you look at, though GATT did not deal with IPR as such, but there are certain provisions like Article 9 of the GATT agreement talks about marks of origin, where from goods are coming. So maybe they have kept that part of the taxation point of view, but it also related to IP. So Article 9, then Article 20 talks about patent protection, trademarks, copyrights, and prevention of deceptive practices. These, are two important articles part of the GATT. Other articles, including Article 1, we are going to talk about that MFN, national treatment, dispute settlement. These were some of the articles which directly or indirectly dealt with the IP protection. I can say by and large, IP was considered as a acceptable obstacle for free trade until Tokyo round of 1977. This is the I can talk about the pre-TRIPS agreement. But the important thing we have to mention here is the WTO. When I say WTO IP regime or WTO related thing, so before talking about WTO, there were this Uruguay round. You all know that earlier part of the GATT system. GATT was established with 1947. It came into force 1st January 1948 to 31st December 1994. GATT existed. So in the GATT regime, they used to have rounds of negotiations. Prior to Uruguay round, there were 7 rounds of negotiations happened. They talked about trade, other aspects. But Uruguay round is very important because TRIPS agreement is part of the Uruguay round. That's why I'm just mentioning need, goals, and achievements of Uruguay round. Why Uruguay round? Of course, one is various failures of the Tokyo round, particularly market access and other things. Not only that, but if you look at why a comprehensive round of negotiations required is 1980s world trading system has changed, liberalization, privatization, globalization, all these things happened. Then, investor required, guarantees in, investments, IP protection required better thing. So these are some of the ideas they, necessitated to go for comprehensive Uruguay round. Or if I say, what are the goals of Uruguay round? Nothing but further liberalization. Liberalization is part of the GATT earlier, but Uruguay round, started further liberalization through reduction of tariffs and, international promotion of international trade and protection of IP regime, then investments, then services. Important thing is service sector. All these things, they included a very comprehensive round. And of course, this round, I can say that from 1986 to 1994, if you look at more than 120 countries participated, present, discussed, agreed, disagreed, and all those things. Uruguay round, as a student of international, I can tell you, friends, this is one of the important treaty which was most controversial in the earth. That is the most comprehensive and also controversial treaty which happened from 1986 to 1994. Of course, different countries put different proposals, developed, disagreements were happened between the developed countries, developing countries, all these things. Lot of issues. But the problem with the Uruguay round is without understanding, lot of new issues which happened. So even India, if you take when India signed then we call GATT agreement. Of course, now we have WTO. The many countries, including India. So we expressed our apprehensions that if we are part of these, that's called uncle draft area. India is going to lose its sovereignty. In fact, they used some of the, people used. That time it was a P.V. Narasimha Rao government. Both the rightist, leftist, everybody criticized, parting to the WTO treaty or GATT treaty that time. So said India mortgage its sovereignty. Agriculture, prices will shoot up. Farmers have to buy their seeds. Multinationals. Those kinds of apprehension they expressed when we proceeded with the WTO TRIPS agreement initially. But of course, finally, what happened? These are all agreements. Disagreement happened. What was the outcome of the Uruguay round negotiations? From 1986 to 1993. This outcome is this what we call Marrakesh Agreement or Uruguay round established two important things. One is the creation of World Trade Organization. Okay, this though part of the Bretton Woods institutions way back in 1944-45, if you look at after Second World War, international community created United Nations. You all know why United Nations, because of World War, to prevent Third World War, to save succeeding generations, all those things. The UN was created to maintenance of peace and security. That time itself, the international community gave focus on trade business. That's why three Bretton Woods institutions, they are supposed to create like, IMF, IBRD, ITO. Okay, IMF for monetary regulations, IBRD, International Bank for Reconstruction and Development, for development of developing countries, reconstruction of Europe, all those things. These IMF, IBRD was created, but the third one, ITO, International Trade Organization, supposed to create, but it could not happen because of politics, other things. In place of ITO, GATT happened actually. That's the link I am trying to give you. GATT was created ad hoc organization. So they were hoping, international community was hoping that ITO will come into force, but it could not happen. In place of ITO, the GATT agreement, though initially they thought that it is a ad hoc arrangement, stopgap arrangement. That's why they put thought, but finally, friends, ITO could not happen. This ad hoc arrangement was continued for almost 48 years, if I say from. That's why I used the word 1st January 1948 to December 31st, 1994. This agreement, existed, continued, international trading, including some of the IP issues, which part of that. So that is the, background of this thing. But finally, this 1986 Uruguay round, 80s Uruguay round, final outcome was that it created a World Trade Organization, which supposed to create, after Second World War, then putting important treaties as annexures to the WTO. Not only they created WTO, but they also put important treaties as annexures to the WTO. So one is WTO and other, there are, 4 annexures, of course, now more importantly 3. And that's why, friends, one thing, you are all part of IP. I know you are enthusiast or, interested IP, but we should not look IP in isolation with the trade. Today, the moment when you talk about the intellectual property, we had to know about the WTO. Without WTO, understanding of intellectual property, no meaning at all. That's why I mentioned again, I am repeating, though there are 20 plus important international treaties which regulate different facets of intellectual or property rights, but I am telling you, TRIPS agreement is the agreement. TRIPS agreement is part of WTO. So that's the reason why one should know about WTO also, which will help. Okay, now coming back to the point, achievement of Uruguay round, creation of WTO, plus putting important treaties, annexures to the WTO. One confusing thing about WTO is, friends, actually, for namesake, it is the 3 words, World Trade Organization. But I can tell you, this WTO treaty is consisting of 180 agreements part of the WTO. That is the, I can say complexity with the WTO is that it is not a simple agreement, but I can tell you, friends, it is 180 agreements part of the WTO. Okay, so how these 180 agreements part of that, I'll tell you in a brief. Of course, I'll focus more on the TRIPS, but without understanding the WTO, TRIPS meaningless. That's the reason why I'm just bringing, background 2-3 minutes. So if you look at these, WTO, I said 100 and, IIT agreements, whatever. So what is the outcome? Outcome 1, creation of World Trade Organization. Another one is putting important treaties as annexures. There are 4 annexures. First, I'll tell you, Annex 1 again, deals with 3 important areas. Annex 1A deals with trade in goods. Okay. Annex 1B, that's, deals with the GATS agreement. That's called, General Agreement on Trade and Services, Annex 1B. So this particular agreement to trade in goods, around 12 to 13 important treaties today part of the Annex 1A, including agriculture, all those. Then Annex 1B, GATS agreement consisting of 165 services now part of that. You name any service, it is part of the WTO. Then Annex 1C, that is the link I want to mention you. Annex 1C deals with the TRIPS agreement. Okay. So these first one annex consisting of 3A, B, C. A is trade in goods, B is GATS. Then C is deals with the TRIPS agreement. This is one annex. You see, so many agreements part of one. Then second, Annex 2 deals with the dispute settlement understanding, dispute settlement body. Friends, why again I am mentioning this part of Annex 2? Any disputes relating to anything, if I say 180 agreements, it has to deal by the WTO dispute settlement body. So Annex 1 completely deals with dispute settlement understanding, disputes made. For example, last 20 plus years, around 45 to 50, there are WTO dispute settlement has settled almost 600 plus agreements, cases. Out of that, around 40 to 45 disputes relating to intellectual property. So the point what I am mentioning here is that the dispute settlement body of the WTO is also settle the disputes relating to intellectual property rights. So this is Annex 2. Annex 3 deals with the trade policy review mechanism. Every 2 years WTO meets and reviews how far we achieved the goals, what rest, all these things. That is the trade policy review mechanism. Then Annex 4 deals with the plurilateral agreements. Of course, this Annex 4 is not so relevant to now. Only these Annex 1, 2, 3 are part of the WTO. These are what I said, 180 agreements part of this particular WTO. So that's the, relating to the TRIPS and the WTO. But if you look at the Uruguay round and IP issues, okay, we are talking about the TRIPS segment. What kind of discussion happened in the Uruguay round relating to intellectual property? Of course, here world was divided that time actually. Most of the developed countries insisted that IP should be part of the then Uruguay round negotiations. Our majority of the developing countries, including India, we said that no, IP should not be part of the trading activity. We have already, the IP regime is again, WIPO and international treaty. But anyhow, all these negotiations, all these things, developed countries convinced developing countries that it's the time for us to put the IP part of the trading system. And they assured, I means developed countries convinced or confused or, whatever you use it. But finally, lot of resistance. Finally, they said that no, only IP relating to intellectual property we will put. If you have a reservations for that, including, trade part of this thing. So we don't take every IP, only we will deal with our, the WTO is going to our Uruguay round that time. Uruguay round is going to be part of only trade related intellectual property. We are not concerned with IP, but making, others, fools. Actually, every IP is a tradable thing. You all know that, but anyhow, that time they convinced that only we will take the intellectual property, which something to do with the trade. That's why if you look at the name of the TRIPS agreement, it trade related intellectual property rights. So that is the convincing approach they had. And of course, now they are, made it. And today, of course, it is a story, but, TRIPS is part of the WTO thing. So knowing about TRIPS, anything, whether it's a trade law or, IP law, it has certain basic principles. TRIPS agreement also has certain basic, important, fundamental principles, which, deals with all. If I say WTO, all these 180 agreements, most of the, agreements also deal with these issues. And more particularly, the TRIPS agreement consisting of certain important principles, obligations, or you call it the principles. We know all these things, but I'm putting here as a matter of, discussion. MFN, you all know that, most favored nation treatment or clause, MFN is part of that, and then national treatment, binding commitments, principle of non-discrimination, sovereignty, sovereign equality, transparency, reciprocity. These are all part of the TRIPS agreement. If you analyze, TRIPS agreement, you will find all these things. This is what I call fundamental important principles to regulate international IP receipt. And of course, if I have to talk about the TRIPS agreement, though TRIPS agreement is part of the trade agreement, trade related to intellectual property rights came into force on 1st January 1995, part of the WTO. So that's where it is integral part of the WTO. It lays down norms, standards, for different countries, how to respect, how to enforce intellectual property. So TRIPS agreement was, I said again, adopted Marrakesh agreement, Morocco. Here, though Article 2, Class 7, I was talking about the definition of IP by WIPO Treaty 1967. The TRIPS agreement never defined any, it did not, define the intellectual property, but it has made categorization of intellectual property. If you look at the TRIPS agreement, there are 7 broad categories of intellectual property: copyrights and related rights, trademarks, geographical indications, industrial designs, patents, layout designs, protection of undisclosed information. These are a broad 7 categories which are now part of the TRIPS agreement. Of course, India is the original member in the GATT, and of course, original member in the WTO. Part of that, India also accepted TRIPS agreement. But when India accepted the WTO treaty, I said, a lot of apprehensions. We developing countries in general, including India, express a lot of apprehensions that, IP will be dominated by the developed countries rather than developing countries. Those kinds of things happened. But anyhow, that was the, again, story history. Today, we are all part of that. There are 164, 65 countries are members to the WTO. They are ipso facto members to the TRIPS agreement. So if you look at the TRIPS agreement, what is the main objective of the TRIPS agreement is to assist members in the understanding of rights and obligations, part of the TRIPS agreement, to assist member countries, participate fully in cooperation with the TRIPS Council and other member countries, ensure complementarity with cooperation. TRIPS agreement is not contradiction to the existing IP. We all confused with, but I'm using the word complementarity. Okay, and cooperation. The TRIPS agreement enforcement is there, and particularly if you analyze the TRIPS agreement, entire TRIPS agreement, I'm going to look at that 73 articles, like 7 parts. But what are the takeaways of, if you analyze all these 73 articles? One is standards. Respect of each main areas intellectual property covered TRIPS agreement. The agreement also said minimum standards for protection provided by each member. Okay, if you are a member, what you supposed to do? That's why. Then enforcement. Other important thing about the TRIPS agreement is not only it sets standards, but it also sees that enforcement. So enforcement is the main lack the enforcement mechanism. That is the one lacuna I can say, and that is one beauty with the TRIPS agreement is that enforceability. So one of the important thing, the domestic enforcement is issues, but here enforcement of TRIPS agreement, I'll talk about that latter part of my discussion. But enforcement is one of the important characteristics of TRIPS agreement, I can say. Other important issue, if you look at dispute settlement mechanism. Of course, you all know that disputes and disagreements part of the intellectual property. So how to settle the disputes, where to go, which is the forum, right forum to settle the disputes. Of course, part of the DSU, DSP, I was talking about any disputes relating to intellectual property. Again, it has to go to the WTO dispute settlement body. I'll talk about that. So silent features of TRIPS agreement, if you look at the harmonization of IP standards, the main, because every country has their own IP, how to regulate, how to control, how to enforce it. So harmonization is one of the important thing part of the TRIPS agreement. Encourage flow of technology, more particularly adequate safeguards are given to the LDCs, developing countries. Prevention of abuse of IP rights by right holders, and includes the TRIPS agreement included nuclear energy, then of course plant varieties, all these new things, fair and equitable procedure of all countries. These are some of the silent features of the TRIPS agreement. And main, I was mentioning about the basic important fundamental principles of TRIPS agreement, MFN, national treatment, all those. But to understand that, what is the TRIPS? TRIPS, I said again, repeating, being important treaty, or I use the word the treaty. 73 articles divided into 7 parts. Of course, first part, Article 1 to 8 deals with general principles and obligations of countries. What are the general principles? What is the objective of IPR? I am going to talk about that. The objectives, purposes of intellectual property. TRIPS agreement is provided, part of the general principles. Then part 2, issues covered. I said TRIPS did not define the intellectual property rights. TRIPS categorized 7 kinds of our categories. I mentioned copyrights related rights, trademarks, geographical indications, all these from Article 9 to 40. If you look at very detailed discussion was provided, all these 7 categories. And the third part, if you look at a new part and compared to earlier treaties, enforcement of IPRs, part 3 from 41 to 61. Friends, you all know that importance of enforcement is a cumbersome process, is a particularly enforcement is a big challenge in international IP or international context. There is a before I think yes, I have a time, just 2 minutes. When I say enforcement, TRIPS article from Article 41 to 61 deals with almost 21 articles devoted kind of enforcement, how to enforce. So how TRIPS agreement enforcement mechanism is different from the earlier thing. That elaboration is provided. How India enforces, I'll talk about that. Then part 4 talk about the acquisition and maintenance of IP rights. Then dispute prevention and settlement. If you look at Article 63, 64 talk about dispute prevention and protection. You all know that prevention is better than cure. But if you don't prevent, then what is the mechanism to be adopted to settle the disputes? Of course, Article 64 has given powers to go to the WTO dispute settlement body. And then transitional arrangements, when shift coming from developing countries to developed countries, when IP regimes, they have given a lot of concessions, form of time limits. For developed countries 1, developing countries 5, least developed countries 10. Like these transitional arrangements, enforcement will be different countries for different time frame. Then final provisions. All these 73 articles, very elaborative thing. So generally, I said the objectives or goals. If you look at TRIPS agreement, is reduction of distortion and impediments to international trade, because trade, we are talking about intellectual property, promotion of effective, adequate protection of IP, ensuring the member countries' rights. General goal is to Article 7 very clearly mentioned objectives. The general obligation is that if you are a member, you have to implement that. So particularly the balanced growth of IP and other things. When I say the IP protection, member countries' role, though becoming a party to any international treaty, not only TRIPS, but it is a voluntary, or it is the sovereign prerogative of the member countries. Whether India wants to join X treaty, Y treaty, it is the sovereign prerogative of government of India. But friends, once you join, once you are party to treaty, then your obligation comes, you implement it. You have to implement. So option is whether you want to be party or not, it is up to the sovereign countries prerogative. But once they are party, they have to implement. So that's where the obligations mentioned, particularly Article 8, principles recognize rights of members to adopt measures for public health and other public interest related things. All these are objectives provided from Article 1 to 8. Then I said the beauty of TRIPS agreement is it has opened new horizons for industrial, including pharmaceutical. It plays an important role for protection, not only protection, transfer of technology, inspiration of transfer of technology among member countries, adequate protection of intellectual property, all minimal protection. These are all part and parcel of the TRIPS agreement. And one thing, TRIPS agreement has tried to protect the interest of developing countries to the extent possible. Okay, so there are, if you analyze those 73 articles, 7-8 articles completely devoted to the developing countries. So this is important contribution from the TRIPS agreement to the developing countries. I can say that the main mandate TRIPS is enforceability. TRIPS agreement or TRIPS mandate is to enforce IP. I said specification, of measures for procedure to left member countries. Of course, they will put minimum standards, but again, member countries have to adopt. How will they enforce? What is the mechanism, they adopted? How this mechanism is different from the existing international treaties? If you look at, friends, article, I said 41 to 61, very important part. It says civil and administrative actions, injunctions, declaratory judgments, compensation. These words we never heard any treaty except TRIPS agreement. So that kind of stringent procedures have been adopted by the TRIPS agreement for effective enforcement of this particular international treaty. When I say enforcement, of course, domestic legislations, including enacting acts, laws, all these things, member countries have to enforce it. Establishment of proper administrative procedures, streamlining appellate procedures, civil criminal remedies, all these things are part of the enforcement mechanism. When I say enforcement mechanism compared to earlier one, I said these injunctions, declaratory, these things never used any international treaty, but that shows that how stringent enforcement mechanism is provided in the TRIPS agreement. We can understand this. So finally, one thing I just want to enforcement, when I say how India is going to how India is enforcing, implementing international treaties, or I can say one word I can use, domestic enforcement of TRIPS agreement in Indian context. Okay. So when I say domestic enforcement, I want to clarify one doubt, friends. Enforcement is a big challenge, not only TRIPS agreement, any international treaties. Reason is that international law, normally law is is above everybody, and most of the domestic laws are enforced through a institutional backup. When I say institutional backup, you take any country. I'm giving example, India or any country. Institutions are there to enforce law. For example, legislature to legislate, executive to implement, judiciary to interpret. Do we have these things in international context? We don't have. You haven't heard World Parliament or World Executive. Of course, we heard sometime about the World Court or ICJ. But how ICJ get jurisdiction? Consent of the parties. So all these are all issues. So what I'm trying to put here is that enforcement is a big challenge to any country, for sake India or any member country. So it is the obligation. Member countries have to enforce it because they are party to treaty. I said again, I am repeating, though becoming a party to the any treaty is country's choice. But once you are member to any treaty, not only TRIPS agreement but any treaty, your obligation comes, whether you call it a legal obligation or moral obligation. Nobody asked you to join TRIPS agreement or WTO agreement. Once you join, then you have to implement. So how will you implement? Through domestic enforcement. So one today, in more particularly TRIPS related thing, when I am talking about the enforcement and more particularly TRIPS agreement, I can tell you, friends, actually there is a I always used today the global scenario, international context, the increasing or reduction of sovereignty is happening. Role of states, I'm using the proper word. Role of states means countries. Role of states are changing from lawmaker to law taker. When I say lawmaker to law taker, what do you mean by law? So are we not making law? Is Parliament is not making law? Yes, definitely Parliament is making law, but lot of laws are coming from international treaties. That's why I use the word, role of states are changing from lawmaker to law taker. And I can give best example is the TRIPS agreement. Today, TRIPS agreement, I use the word the agreement, and today enforcement of TRIPS agreement is happening almost with all member countries. If you take India, of course, last 20 plus years, the internet in the today IP regime, if you say Indian intellectual property rights are nothing but TRIPS agreement, in compliance with TRIPS agreement. Maybe I am biased as a student of international law. I am putting little overemphasize, but it's fact. I'm telling you today, whatever the intellectual property we have had today in India, it is part of the TRIPS place, TRIPS part of that. How you may ask questions, are Patent Act was there way back in 1970, but TRIPS agreement came in 1990s. So how? Yes, there were some legislations were there, but we made all the changes which required. I can say that the amendments which made the legislations which we have already, for example, patent law was there, but we inserted all the amendments, or we made amendments. Some of the legislations we do not have had. once India became party, then India is supposed to have a domestic law, for example, geographical indications and other things. So the TRIPS agreement, the enforcement of TRIPS agreement is in India is happening in toto, or what I said, lawmaker to law taker. It suits to many countries. India is no exception. This is the thing. So all today, whatever TRIPS says, TRIPS, part of the TRIPS provisions we are following, we have to follow. Of course, again, one may ask questions, sir, is it compulsory if, certain provisions are detrimental to the sovereignty, security, these things? Of course, there are exceptions, but those are exceptions only. But majority of the time, countries are in compliance with, in tune with, in consonance with, I can say that part of the TRIPS agreement, and India is truly implementing, though India is trying hard to implement this TRIPS agreement, through making legislations and, creating judicial, enforcement. I was referring Article 41 to 61. India also, came out with the legislations, and of course, we created a lot of tribunals and, other judicial mechanism to enforce TRIPS agreement. So, and, finally, I'm talking about the enforcement. So I said domestic enforcement is a big challenge because international law does not have its own machinery. International law has to depend on countries. Remember, ultimately, how good treaty you formulate or bring, but it's ultimately the sovereign countries have to adapt. Sovereign countries have to implement. Of course, in India, you all know that, friends, India, we follow the dualistic method of implementation of international law. When I say dualistic method, international and domestic law, two different branches. If we are to implement international treaties, international law, then we have to, these, it should not conflict with domestic law. So majority of the time, not always. So India follows dualistic method. We believe that Indian law is compared, supreme, then international law. Majority of the time, not always, but B. So as long as there is no contradiction, no problem. If international law is conflicting with the domestic law, then it is the domestic law which prevails. We have hundreds of cases, Supreme Court of India, various high courts also now following this method. So it is true with implementation of intellectual property also. So we created institutional mechanism to implement. We enacted the existing legislations, and we are part of all the the machinery which we created. I can say mandate. That's why I said TRIPS mandate to enforce is the general obligation, civil and administrative procedures, border measures, the criminal procedures, all these things. Part of the TRIPS agreement, we in India also implementing. And I said legislative, administrative actions. What kind of initiatives we have initiated to implement the TRIPS agreement? We have Designs Act 2001, Trademarks Act 99. These are all geographical indication, Foods Act 99. These new legislations and the existing legislations like patents amendments, we have amended 3-4 times to include TRIPS and TRIPS plus agreements, modernization of current IP infrastructure, new administrative initiatives, including establishing offices for patent trademarks in all 4 metros, geographical indication registry we set up in Chennai, release of draft manual. These are all some of the initiatives India also initiated, and we are working towards to implement the TRIPS agreement or post-TRIPS scenario. So I can say that. So with this, yes, I will stop here. We can have some discussion, or I think. So I know a little bit, fastly I've checked. I was trying to give as much information I can give in 1 hour.
Now I request our colleague, Mr. Srinivas Rao, to propose a formal vote of thanks. Over to you, Srinivas.
Thank you, sir, for your wonderful talk on the topic of IPR protection, pre and post TRIPS. So first of all, I would like to heartfully thank you on behalf of DPIIT IPR-Chair OU Hyderabad for accepting and addressing the participants here. In today's lecture, you talked about IPR, its history and its brief. You also touched upon the Paris and Berne Convention, IPR regime, WTO Marquis Treaty, United Nations, IMF, ITO, and many more. So you have nicely explained all the concepts related to TRIPS. Most importantly, the TRIPS pre-scenario as well as the post-scenario, how it was implemented and what are the effects. So it's a great insight and a very nice professional analysis for everyone. So thank you once again, sir, for this interesting session. And we look forward for more sessions similar to this, maybe on the other topics, because we know that you have got a diversified experience and academic hold on various topics. So we look forward for those kind of topics. Now for the participants, thank you all for attending this session and posting some of interesting questions. So which also helps us in enhancing knowledge for everyone by this kind of collaboration. Before leaving, please ensure that you have subscribed to our Telegram and YouTube channel to get the regular updates on our lecture series, which is known as Know Your IP, DPIIT IPR-Chair, OU. With this note, I would like to take your permission to conclude this session. Thank you one and all. Thank you.